because Shri Rajendra Pandey, who is Advocate District Court Varanasi, he has to attend some important meeting. So we will have the opportunity to listen him first, and thereafter other speakers will be called upon. Thank you. Mr. Rajendra Pandey.
I feel different manifestations of Lord Shiva, Bhagwan Chandramalishwan, Bhagavati Sharadamba sitting here. I bow down before them. Respected Chairman, dignitaries, school scholars of law and dear students, we are witnessing rather part and parcel the efforts to make our Rashtra Vishwa Guru. We have seen a glimpse of our Sanskriti, of Vasudhaiva Kutumbakam during Corona pandemic. But we are still subjected to a number of age-old laws framed by the British rulers for their slaves. We still some of the undeveloped villages see the justice being ensured by the principle of Panch Parmeshwar. Sahastra Shirsha, I quote Rigveda 1:160, Sahastra Shirsha Purusha, Sahasraksha Sahasrapata, Sabhumim Sartu Stva Vastuda Sangulam. The man who is the absolute source of justice is thousand heads. The man who is the absolute source of justice has 1,000 heads, 1,000 eyes, 1,000 feet, cover the whole earth in step and 10 fingers beyond it. In the trial court, in the appellate court, in the high court, in the supreme court, it is he who comes in person and dispenses justice. With this conception, when we enter into the courtroom, we see a judge who says that I am not your Panch Parmeshwar taught by your ancestors. I am a judge, I am a man, I have to deliver judgment in conformity with the law framed by the British rulers for their slaves. And though he is unbiased, an impartial man, delivering judgment in accordance with law. But what we see in the court today, increasing corruption day by day, we witness that the people at large, including legal fraternity, believe and behave. Everyone is born to die, but an exception would be done in my case. What we witness in court and in the society. In this university, doctors are highly paid, getting NPA, non-practice allowance along with the salary. I remember a case, original suit number 463 of 1985, Adv.Rajendra Pathak versus BHU, in which my friend Dr. Arvind Joshi was also a plaintiff, co-plaintiff. It was decreed by Mr. Triyogi Narayan Mishra, First Additional Civil Justice Senior Division Court number 1st Varanasi on 24th May 1995. What the important observation was made by the judge, Sir Sundar Lal Hospital, BHU, has become a slaughterhouse and it should be closed in public interest. It was published on 26th of May 1995 in Rashtriya Sahara and other newspapers on 26th May 1995. The first appeal filed by the BHU was dismissed by late Justice Kashinath Pandey, with an additional decision court number 6 Varanasi. On 29th of September 1998, and it was published in all over the country on 4th of October 1998. So this is the society where we live. The doctors on emergency duty are leaving, though they are mentioned, they are bound to remain at their residence at least for 24 hours. But They are visiting the city on private visit and earning money. The question arises, are the existing laws enough to make life easier for every citizen? Good laws make good societies. Law can be simply defined as a system of rules that are used to regulate a society or rather control it. Law is the supreme authority in the hands of the state to regulate what is right and what is wrong in society. Traditionally, the norms that were followed by society to regulate itself in order to infuse the elements of uniformity, consistency, development of society, the norms that were accepted by society took the shape of law. Since I have the restricted time, I will directly come to Article 14 of the Constitution of India. We borrowed equality for law from the British and equal protection of laws from the Americans. There is a case, three black students had applied for the admission in white schools and they were denied admission. Brown versus Board of Education of Topeka 347 US 482 dated 17th May 1954 was learned by decision of US Supreme Court, which ruled that US state laws establishing racial segregation in public schools are unconstitutional. Even the segregated schools are otherwise equal in quality. That the racial segregation in public schools violated the 14th Amendment to the Constitution, which prohibits the state from denying equal protection of the laws to any person within their jurisdiction. Although the 1954 decision strictly applied only to public school, it implied that segregation was not permissible in other public facilities, considered one of the most important rulings in the history of Supreme Court of USA. Brown versus Board of Education helped to inspire the American civil rights movement of the late 1950s and 1960s. Now in our Constitution, Article 29 and 30 of the Constitution of India give special protection to the minorities. In TMA, Pi Foundation was the state of Karnataka, and the Supreme Court dealt with the autonomy of minority education institutions and their right to establish and administer institutions of their choice. It was held that minority institutions have the right to administer their affairs, including the right to appoint staff, but they must still operate within certain reasonable regulations imposed by the state. At one point of time, we see that there is a special protection in Article 29 and 30, Sub-Article 1A and 30, Sub-Article 2, giving special protection status to minorities, but Constitution 42nd Amendment Act 1978 repealed Article 19(1)(f) and took out Article 31(1) from Part 3rd and made a separate Article 300A in Chapter 4 of Part 2nd 12. Now the people lost the scope of speedy remedy under Article 32 for the violation of right to property because it is no more a fundamental right. We have witnessed in last 75 years that the teachers of the well-known institutions run by the minority. I am the council of Diocese of Varanasi, and I have seen the teachers of the institutions run by the minority. They have no time to participate in politics and fight general elections, become MLA and MP, while the teachers of the institutions run by the majority have enough time to take active part in politics and fight election, leaving aside their primary duty to impart education, which has adversely affected the quality of the education. I have found a trust here in Varanasi, Maharani Lakshmibai Seva Nyas. Then I recollect the first war of independence, India's independence 1857, led by Maharani Lakshmibai, jointly fought by Hindus and Muslims. The British Crown had taken control of the country from the hands of East India Company. On 2nd of August 1858, Government of India Act was passed by British Parliament, and thereafter the policy of divide and rule was adopted, which is continuing since then. A glimpse of the same is seen in Waqf Act 1995, in which a tool given to Waqf boards to snatch the property of Hindus. Waqf Act was first passed by Parliament in 1954. Subsequently, it was repealed and a new Waqf Act was passed in 1995, which gave more powers to Waqf boards. In 2013, this act was further amended to give unlimited powers to Waqf boards to snatch anyone's property, which even could not be challenged in a court of law. In March 2014, just before the commencement of Lok Sabha election, the Congress gifted 123 prime properties in Delhi to Delhi Waqf Board by using this law. Due to this black law, thousands of acres of land of Hindus have been snatched away in the country so far. Recently, Tamil Nadu Waqf Board has declared 6 villages of Tamil Nadu, including a 1500-year-old temple, Hindu temple, as Waqf property. In fact, the Hindus who came to India after partition from Pakistan, their properties in Pakistan were occupied by the Muslim and the government of Pakistan. But the government of India gave the land of Muslims who went from India to Pakistan to the Waqf boards, earlier constituted by the British rulers. At this juncture, without going into matter, I would like to refer the first Gyanvapi case in which I am the counsel for the Hindu Paksha. Suit number 610 filed under Order 1 Rule 8 of the Civil Procedure Code after taking permission from the court. Suit number 610 of 1991, Ancient Order of Swambhu Lord Vishweshwar and others versus Anjuman in the Jamia Masajid Varanasi and others. It was filed for a decree of declaration that the structure is standing over and above the cellars and the adjoining part of the old temple of Plenty number 1, together with Naubat Khana towards north of the temple of Lord Vishweshwar and the house lying to the east of said Naubat Khana is the property of Plenty number 1 and the devotees of Lord Vishweshwar, that is Hindus at large, have every right to use it as a place of worship and to renovate and reconstruct their temple, adding it with the... So I want to just to say this, that the all other 22 cases filed here, the only case is for the title of the property there. UP Sunni, the important thing is UP Sunni Central Board of Waqf, Lucknow had moved an application under Order 1 Rule 10 of the Civil Procedure Code for impleadment and was impleaded, was ordered dated 2nd July 1994. Thereafter, the board had moved an application for transferring this suit to Waqf Tribunal constituted under Section 83 of the Waqf Act 1995, so that the matter may be decided by a Muslim judge exclusively under the provision of Waqf Act 1995, but the same was dismissed on 25th of February 2020. Then 2 revisions have been filed by the defendants, which are pending in the court of District Judge Varanasi. Thank you very much.